Carpenter. I'd like to thank you for taking the time to join me on today's program. On today's program, we're beginning a brand new series entitled The Prededential Cases, Medical Legal Game Changers. And the philosophy of this program is that in all of the cases that we have an opportunity to review, and all of the cases that pass through the workers' compensation system on a weekly, monthly, and annual basis, of all those cases, there are a few cases that are extremely important in the day-to-day practice of the procedures that we employ as qualified medical evaluators. So the philosophy of this program is what I refer to as the 80-20 rule of cases. And what that means simply is that of all the cases, only 20% of the cases are important. In fact, 20% of the cases that occur and that pass through the Workers' Compensation Appeals Board, 20% of the cases provide you 80% of the procedures and 80% of the governing philosophy of your QME reports that will satisfy 80% of all situations, circumstances, and scenarios that you will ever encounter. These are the precedential cases that change the face of workers' compensation and change the face of qualified medical evaluations as we know it. And these precedential cases are going to span the time period from 1 year to 2 years to 5 years. And some precedential cases even occurred as many as 15 to 20 years ago, but are still applicable today to the practices and procedures that we as qualified medical evaluators employ in our face-to-face evaluation and then also in our report preparation and even in regards to our deposition preparation. So these are the cases that you really need to know, and you really need to know them really well. So these are the cases that are going to have immediate impact on your very next evaluation. So that if you can master these few cases, these 20% of cases that will handle 80% of all the scenarios you'll ever encounter, if you can master these cases and become fluent with these cases and be able to quote citations from these cases, you're basically going to have it whipped as a qualified medical evaluator, and you'll be able to handle yourself extremely well, both with the injured worker and subsequently in defending your reporting in your qualified medical evaluation report, and then also in supplemental report, and then also by way of deposition, should some of the parties challenge your opinions and conclusions. So I have 6 fascinating cases to share with you. 5 of the 6 you may have heard of and you may be somewhat remotely or vaguely familiar with. And then I have a 6th case to share with you, which is going to be an absolute mind blower for you, which perfectly illustrates several of the principles that are espoused in the first 5 cases. The 6th case hits those 5 cases home with a grand slam home run and perfectly illustrates the principles espoused in the previous 5 cases. So I have 6 fascinating cases to share with you, which I expect will dramatically change your QME practice from here on out if you can become familiar and fluent with these cases. So with no further ado, let's begin today's program entitled The Precedential Cases. And these are the medical legal game-changing cases. Okay, so here's a listing of the 6 cases that I want to share with you in this program. And we're going to go through these cases with a fine-tooth comb and extract from them the important principles that are relevant for us as qualified medical evaluators. So we're going to be talking about the Escobedo case, the Alvarez-Guzman case, the Kite case, the Cannon case, the Benson case, and then a case that you probably have never heard of, which is the Mendoza-Garibay case. And each of these cases is going to bring to us an important principle that's relevant to every single evaluation that we perform. And I have them listed here in no particular order, although it seems that they may perhaps be in their order of relevance to us in our day-to-day QME procedures. Some might argue that the Alvarez-Guzman case is even more important than the Escobedo case, and that may well be true. But we're going to begin our discussion with the Escobedo case, and then we'll get into these other cases as well. And before we begin today's discussion regarding the Escobedo case, let me just share with you some of the important principles that these cases bring to our day-to-day procedures, so to set the tone for today's discussion. So with the Escobedo case brings to us important principles regarding substantial medical evidence, particularly as relates to our apportionment determination, but also as relates to every single opinion and conclusion that we offer in our report. So we're going to define substantial medical evidence, and I'm going to show you how to fashion and fabricate and formulate your opinions and conclusions on any issue in your report, so that your opinion and conclusion qualifies as substantial medical evidence. And so therefore, when it qualifies as substantial medical evidence, it then qualifies as an opinion that can be used by the parties. The parties cannot use opinions unless those opinions rise to a certain level. And the threshold level is what's referred to as substantial medical evidence. So you're going to become an expert in fashioning your opinions and conclusions as a result of the principles that are going to be handed down to us from the Escobedo case. Additionally, and also perhaps on a more subtle basis, the Escobedo case is famous for ushering in a new era, and it ushered in the new era of the importance of the mechanism of injury with regards to your apportionment determination. So if you've listened to any of my prior discussions, or even my prior continuing education programs on apportionment, you'll recall that your apportionment opinion must be based on what are referred to as relevant facts. So of all the relevant facts that go into your apportionment determination, one of, if not the most important of the relevant facts, has to do with the relevant facts associated with the mechanism of injury. The Escobedo case ushered in the new era of the importance of the mechanism of injury in formulating the physician's apportionment determination. So we're going to talk about the importance of the mechanism of injury and how to incorporate intense interrogation in your face-to-face evaluation regarding the mechanism of injury, so that later on, when it comes time to provide your apportionment determination, you have copious relevant facts upon which to formulate your apportionment determination. And when you have relevant facts, your opinion can then rise to the level of substantial medical evidence. So this is going to be a critical discussion that we'll get into here shortly. With regards to the Alvarez and Guzman series and line of cases, this is a line of cases that dramatically changed our entire operating procedure when it comes to providing for your permanent impairment rating for your examinee. And it's the Alvarez-Guzman line of cases that unpopped the cork, or let the jack out of the box for higher and higher permanent impairment ratings in those cases wherein the permanent impairment rating under the strict application of the guides, using the charts and tables within the AMA guides, resulted in an unfairly low permanent impairment rating. It was the Alvarez and Guzman line of cases that allowed QMEs to provide double, triple, quadruple, even 10 times the permanent impairment rating that would otherwise be assigned to the examinee under the strict application of the AMA guides. So this Alvarez and Guzman line of cases changed everything. But if you're going to provide for alternative impairment ratings under Alvarez and Guzman, which have the effect of doubling, tripling, quadrupling the permanent impairment rating, it has to be done just right. And I want to share with you those exact principles and the exact procedure for providing for alternative impairment ratings in those cases wherein you deem it appropriate to depart from the strict application of the AMA guides and to provide an alternative impairment rating within the four corners of the AMA guides. So you're going to become an expert and fluent in the Alvarez and Guzman cases. Then I have an interesting case for you. You've probably heard of it. It's a takeoff on the Alvarez and Guzman cases. It's referred to as the kite case, and the kite case is a unique and specific application of Alvarez and Guzman. It still operates within the four corners of the AMA guides, but it's a way that qualified medical evaluators have discovered through a liberal interpretation of some of the philosophy contained within the AMA guides that allows for higher and higher permanent impairment ratings through the use of adding impairments versus combining impairments. Now, typically when we combine multiple impairments, we use the combined values chart on page 604 of the guides. So if we have, for example, an impairment of the cervical spine, and we have an impairment of the lumbar spine, and we have an impairment of the right knee, for example, we combine those impairments through the use of the combined values chart on page 604, and the combined values chart has a reductive effect, such that a 20% impairment for the cervical spine, plus a 20% impairment for the lumbar spine, plus a 20% impairment for the right knee, might combine to perhaps a 51% total whole person impairment. In other words, the 20 plus 20 plus 20 are not additive, they are reductive through the use of the combined values chart. Well, the kite case provided precedent for simply adding impairments versus combining the impairments in certain cases and in certain scenarios. So I'm going to share with you a list of scenarios wherein you can employ the kite case if you feel it's appropriate that the examinee deserves a higher impairment rating than would otherwise be provided through the reductive effect of the combined values chart. Okay, so that's going to be a fascinating discussion. I have a fascinating case for you referred to as the Cannon case. And again, the Cannon case is an example of an Alvarez and Guzman alternative impairment rating. That's absolutely a mind-blowing case. When I first read the Cannon case, I was just blown away by the creative application of the AMA guides in a case where the examinee had none of the physical examination findings, none of the diagnostic study findings, and none of the subjective complaints that go with the impairment rating that the qualified medical evaluator provided for. But the qualified medical evaluator provided the impairment rating by analogy, by saying that the examinee's situation was similar to the permanent impairment rating described in the guides, when in fact there was no tangible similarity at all. And yet the qualified medical evaluator's opinion was upheld by the workers' compensation judge. And so it was a fascinating application of Alvarez and Guzman that really unlimits our imagination to the types and numbers of permanent impairment ratings that we can employ in these cases. The Alvarez and Guzman line of cases unlimit our imagination, and the Cannon case is one example of such an unlimited imagination that it really is illustrative for us in letting us know that we really have no limits as qualified medical evaluators. As long as we operate within the four corners of the AMA guides, we can provide impairment ratings really in any fashion that we want, as long as that opinion can be supported through substantial medical evidence. Okay, so that'll be the Cannon case. And then the Benson case is a fascinating case. And there are several series of cases that have come after the Benson case, which we'll talk about. But the Benson case has to do with two dates of injury that become permanent and stationary at the same time. So say, for example, you have an examinee who has an injury to their lumbar spine on January 1st, 2019, let's say. And they receive medical treatment and they're undergoing medical care. And then 6 months later, they have another industrial injury that worsens the lumbar spine. And eventually the examinee requires a surgical procedure for the lumbar spine. So we have 2 dates of injury to the same body part. Well, imagine that this examinee becomes permanent and stationary at 6 months or 12 months after the surgical procedure, and both of those injuries are now permanent and stationary. Well, the law requires that we provide a permanent impairment rating for the examinee at the time he's at maximum medical improvement, but the law requires that we provide an apportionment determination to tell the reader and tell the impairment rater how much of the permanent impairment was due to the first injury and how much of the permanent impairment was due to the second injury. We're required by law to do that. Well, with the Benson case addressed those situations wherein the qualified medical evaluator was unable to differentiate the permanent impairment between the 2 dates of injury. And the qualified medical evaluator opined that the 2 dates of injury were so inextricably intertwined, that's a key phrase, inextricably intertwined, that it was impossible to provide an impairment rating for each of the 2 injuries separately. In other words, it was impossible to provide an apportionment determination for the 2 separate injuries, but rather the qualified medical evaluator opined that the 2 dates of injury were inextricably intertwined and could not be separated, and therefore the examinee qualified for a combined award rather than 2 separate awards. It qualified for a combined award of permanent disability, and the combined award of permanent disability was substantially higher than the 2 separate awards, even when they were added. But now, since the Benson case has come to pass, judges are no longer tolerating the qualified medical evaluator's opinion that 2 dates of injury are inextricably intertwined, and the workers' compensation judges are now demanding that the qualified medical evaluator go through the difficult decision-making process of separating out the permanent impairment due to the 2 dates of injury. Now, this is a difficult thing to do, and we'll discuss just how to do that when we get to that case. And then finally, I want to share with you the Mendoza-Garibay case. The Mendoza-Garibay case, because the Mendoza-Garibay case illustrates what I refer to as liberal construction times 3 or even times 4. And as you know, Labor Code 3200 or 3202, also known as the Liberal Construction Code, requires that at least at the court level, that the court liberally construe the workers' compensation laws for the purpose of extending benefits to persons injured on the job. Well, with the Mendoza-Garibay case, the Mendoza-Garibay case was a denied case. So the denied case came to the qualified medical evaluator for an AOE-COE determination. So not only did the qualified medical evaluator apply liberal construction in opining for FOR, industrial injury, he applied liberal construction in providing a very high permanent impairment rating. He then increased the permanent impairment rating through an Alvarez and Guzman alternative impairment rating, and then he further applied liberal construction in providing for 0% apportionment to other factors. So what began as a denied case, no benefits were projected to be provided for this particular examinee, through application of liberal construction at least 4 times, the qualified medical evaluator dramatically changed the direction of this case, which provided for huge benefits for this injured worker for what otherwise was initially a denied case. So I have some fascinating principles to share with you that are going to be applicable to every single case from here on out for the remainder of your career. So let's get into today's discussion, which has to do with Marlene Escobedo versus Marshall's Retail Department Store. Okay, so let's talk about the Escobedo case. And you've probably heard of the Escobedo case. And it's important to keep the Escobedo case at the forefront of your consciousness, because every single report that you're going to write from here on out to the remainder of your career will rely on principles that were elaborated in the Escobedo case. So if you can master the Escobedo case and master the principles involved in the Escobedo case, you can feel confident that the opinions and conclusions that you provide in your qualified medical evaluation report, those opinions and conclusions will be upheld by the judges, will be upheld by the appeals board, because the opinions and conclusions that you provide will have passed through filters, will have passed through truth filters, such that when the opinion finally falls out of the bottom of the truth filters, what's left is an opinion that is true. It is true. In other words, in this business, we don't employ crystal balls. Many times there are things that we're not 100% certain about. And we don't really have firm, definitive answers in the medical legal evaluation business. But when you pass your opinions through the truth filters of substantial medical evidence, what falls out of the bottom has a very high likelihood, almost as if you had a crystal ball, has a very high likelihood of being pretty darn close to the truth, as close as we can get with the technology that we have available. And it's the Escobedo case that gave us the technology to qualify our opinions. It gave us the filters through which our opinions must pass in order to come out the bottom as an opinion that's referred to as substantial. So let's talk about these principles. Now, the Escobedo case happened at a time almost 15, almost even 20 years ago, when we were at the transition between the old workers' compensation system and the new workers' compensation system that we now know under Senate Bill 899, which passed and became effective on April 14, 2004. So these dates and timelines are going to become important and relevant in understanding the Escobedo case. So the Escobedo case involved a 2002, in other words, pre-Senate Bill 899, a pre-Senate Bill 899 date of injury. It was an injury to the left knee. Marlene Escobedo was working at a Marshall's retail clothing store, and she was coming down some graded steps, not steep steps. She was coming down some graduated steps, and she stumbled and she fell, striking her left knee. Now, she did not suffer any fracture, and it wasn't a severe mechanism of injury. She simply lost her balance, and the details in the Escobedo case are vague on the injury, but it's clear that she was not hospitalized. There was no fractures. There was no dislocations. It was a less than severe mechanism of injury. And the mechanism of injury is going to become important as we go. Well, following the injury to the left knee, she immediately developed, within a couple of days, she immediately developed pain in the right knee. So there's a compensable consequence injury to the right knee. And then shortly thereafter, in 2003, she underwent a surgical procedure of a left knee medial meniscectomy in 2003. Now, the AMA guides became our operating Bible after the passage of Senate Bill 899 on 4/14/2004. So had this been rated for permanent impairment under the AMA guides, a left knee medial meniscectomy ranges anywhere from 1% to 3% whole person impairment, depending upon whether it's a partial medial meniscectomy or a full meniscectomy, so 1 to 3%. But this was rated according to the 1997 Permanent Disability Rating Schedule, which used a different series of descriptors, okay? And then we'll talk a little bit about those descriptors. So shortly thereafter, 3 months later, the primary treating physician who performed the surgery, he declared the examinee to be permanent and stationary, and he provided a permanent disability rating without apportionment. And he gave a permanent disability rating according to work restrictions. So if you were around before 2004, 2005, you remember that under the 1997 Permanent Disability Rating Schedule, we had 4 descriptors of permanent disability. We had subjective factors of disability, objective factors of disability, work restrictions, and loss of pre-injury capacity. Well, the primary treating physician provided a permanent disability rating according to work restrictions. So this resulted in a permanent disability rating much higher than she would have qualified under the AMA guides, which would have been only 1 to 3%. Okay, well, back in those days, we also had the opportunity for competing medical legal opinions, and so the defense ordered a qualified medical evaluation also to contest the opinion of the primary treating physician, and the defense qualified medical evaluator, he provided for a similar permanent disability rating. In other words, he used work restrictions in describing Ms. Escobedo's loss of pre-injury capacity. But he provided for a 50% apportionment due to other factors, and the other factors included degenerative changes of the knee, as was discovered on imaging studies. Now, this is important, and these timelines are important because you'll notice that 3/15/04, that is a report date prior to the enactment of Senate Bill 899, which was on 4/14/04, which brought in the new apportionment labor code, brought in new changes to apportionment labor code 4663 and gave us new apportionment labor code 4664. So Ms. Escobedo found her case being determined at a transition point between old standards and new standards. And what happened was the workers' compensation judge applied the new standard under Senate Bill 899 in opining and in providing for a final decision that the permanent disability rating should be apportioned 50% to other factors. And the basis for that opinion had to do with the defense qualified medical evaluator's use of language and his qualifying his opinion for 50% apportionment as substantial medical evidence. So let's see how he qualified his opinion as substantial medical evidence. So the sum and substance of the Escobedo case has to do with the apportionment determination and the formulation of your opinion when it comes time for you to provide your opinion on the approximate percentage of the permanent impairment that's due to the industrial injury and the approximate percentage of impairment that's due to other factors. And in the Escobedo case, the defense qualified medical evaluator opined that 50% of the permanent disability, it was at the time, it was disability versus impairment, 50% of the disability was due to the industrial injury and 50% was due to other factors. And the judge upheld this opinion based upon new changes to Labor Code 4663, which became effective on 4/14/04. Well, upon hearing and reading this, the applicant objected, and the applicant had 3 basic objections. Number 1, they objected by stating that Labor Code 4663 did not apply to applicant's date of injury, which was in 2002, whereas Labor Code 4663 became effective in 2004, so that was one objection. Number 2, they contended that Labor Code 4663 does not allow apportionment to pathology where, or I should say similar to pre-Senate Bill 899 apportionment laws, such as Labor Code 4663 and 4750, did not previously allow for apportionment to to pathology, but only allowed apportionment to disability. Did not allow apportionment to pathology, but new changes to Labor Code 4663 do allow apportionment to pathology when it can be demonstrated by substantial medical evidence that the pathology is causing impairment. Okay, so that was a new change to 4663. And then finally, they objected that the defense qualified medical evaluator's report did not qualify as substantial medical evidence with regards to the apportionment determination, because the applicant contended that the defense qualified medical evaluator did not adequately explain how or why he arrived at the 50% apportionment to other factors determination. Okay, and so the Workers' Compensation Appeals Board took a look at these contentions and addressed them one at a time. Okay, so we're going to read from the Escobedo case, but before we do, let's just talk about the Escobedo decision. The Escobedo decision was decided and was referred to as an en banc decision, and it was decided on 4/19/05. So let's go back to those timelines that we were talking about earlier. Ms. Escobedo had her date of injury in 2002, had surgery in 2003, and then in early 2004, the defense qualified medical evaluator provided his disability and apportionment opinion prior to the enactment of Senate Bill 899 on April 14, 2004, and the applicant objected to the workers' compensation judge's decision. So that objection came right before the enactment of Senate Bill 899, and here we see that the en banc decision took place about a year after the enactment of Senate Bill 899. So this case became trapped in the transition between old apportionment laws and new apportionment laws, and it was found that the new apportionment laws applied even to Ms. Escobedo's date of injury, which was 2 years prior to the passage of Senate Bill 899. And this decision was an en banc decision. And what en banc decisions are is en banc decisions are decisions wherein cases are decided by the workers' compensation judge and they're brought to appeal, and they go to the appeals board, and the appeals board renders an opinion, and even the appeals board opinion becomes contested, in which case the chairman of the appeals board brings the matter before the entire board so that the entire board can decide upon the matter and provide a precedent that then has to be applied by all workers' compensation judges and all appeals boards. So this is described in the Escobedo case that reminds us that the appeals board's en banc decisions are binding precedent on all appeals board panels and workers' compensation judges. So because this was an en banc decision, the principles that are elaborated in the Escobedo case are still with us today and still provide the basis for workers' compensation judges and appeals boards' decisions. So these are important principles to understand very, very well. Okay, so let's read from the Escobedo case, and this is directly from the court documents. So applicant, which is Marlene Escobedo, sustained injury to her left knee in 2002 when she fell at her job as a sales associate with Marshalls. As a compensable consequence of that injury, she also developed right knee problems. Ms. Escobedo testified that prior to her fall, she never had any knee problems or limitations, and she had never consulted a doctor about her knees. So what she's telling us with this testimony is that prior to her fall, she never had any disability, for her knees. And it's this testimony upon which the primary treating physician is going to provide his apportionment determination according to laws in effect prior to Senate Bill 899. Now, although her treating physician, her primary care physician, Dr. Cronin, had diagnosed her as having arthritis about 10 years earlier, he did not impose any work restrictions as a consequence of her arthritis. So in other words, she had no documented labor disabling condition. She had no disability, even though she had some form of arthritis, presumably of her knees, although it doesn't specifically describe the knees in the court documents. So she was treated for her industrial injury by Daniel Woods, who performed arthroscopic surgery in 2003 to repair the medial meniscus of the left knee. Shortly thereafter, on June 5th, Dr. Woods prepared a report declaring applicant to be permanent and stationary with bilateral knee disability, so that's both the left and the right knee, resulting in a limitation to semi-sedentary work. So here the doctor is using work restrictions to describe the disability. And as I said, according to the AMA guides, this would have qualified only for 1 to 3% permanent impairment, but this provides for a much higher disability rating under the prior permanent disability rating schedule. He noted that applicant's job duties at Marshall's had required her to be on her feet, standing or walking 6 to 8 hours per day, and to kneel or squat up to 3 hours per day. And apparently she had no limitations, no documented limitations or restrictions in those activities. He had attempted to have her return to work 4 hours per day, but she was unable to tolerate it because of right knee pain. So now, after attempting to return to work, she does have documented a labor disabling condition, at least here of her right knee. With regards to the issue of apportionment, Dr. Woods noted that applicant had no history of any previous problems with her left knee, and thus he concluded that all of her disability was attributable to her industrial injury. And Dr. Woods was not incorrect. What's interesting about this case is that Dr. Woods was providing an apportionment determination based upon laws in effect at the time of the date of injury, which required that in order to apportion, it had to be demonstrated that the examinee had a labor disabling condition as a result of the apportionable factor. So in this case, the apportionable factor was arthritis, and had Ms. Escobedo had some documented labor disabling either work restrictions or need for medical care as a result of her knee arthritis, then he could have properly apportioned under laws in effect at the time. So the doctor actually did his apportionment determination correctly based upon laws in effect at the time. But the defense qualified medical evaluator came along and provided a different opinion based upon new changes to the apportionment laws. So Daniel Ovadia, the defense qualified medical evaluator, he evaluated Ms. Escobedo on 3/15/04, which is slightly about 1 month prior to the enactment of Senate Bill 899, and he prepared a report on that date. He noted that a pre-surgical MRI of the left knee revealed degenerative changes, in addition to the medial meniscus tear, which was operated surgically, and that post-surgical x-rays showed osteoarthritis in both knees. So Dr. Ovadia concluded, based on applicant's bilateral knee condition, that she was limited to 4 hours of weight bearing in an 8-hour day. In other words, he's giving her work restrictions here. That she should avoid very heavy work, that she should avoid more than occasional kneeling, squatting, or walking on uneven ground, that she should avoid stair, incline, and ladder climbing, and that she is totally precluded from running or jumping. So he provided for considerable work restrictions due to the bilateral knee condition. With regards to apportionment, Dr. Ovadia stated, Ms. Escobedo's left knee residuals are directly related to the 2002 date of injury. She developed right knee problems as a derivative of the left knee and not as a result of any subsequent cumulative trauma. And here comes the apportionment determination. He says, in my opinion, there is a medically reasonable basis for apportionment given the trivial nature of the injury. Trivial nature of the injury. That's where the mechanism of injury comes into this apportionment determination. He described the injury as a trivial injury to the left knee. Given the trivial nature of the injury that occurred and the almost immediate onset of right knee symptoms that occurred shortly after the left knee injury. So what he's intimating here or suggesting here is that she had rickety knees and delicate knees prior to the minimal mechanism of injury that occurred on October 28th. Because very quickly, as a result of the left knee pain, she very quickly developed right knee symptoms, and that led him to believe that she had right knee symptoms probably already pre-existing. He stated, the applicant has obvious and significant degenerative arthritis in both knees, and she essentially worked in a fairly congenial environment which was not overly rigorous or demanding on the knees. Although she denied any prior problems with her knees, he says that it is medically probable that she would have had 50% of her current level of knee disability at the time of today's evaluation, even in the absence of her employment at Marshall's. So he stated within reasonable medical probability, given the fact that she had severe degenerative changes on her x-rays, plus the fact that the mechanism of injury was so minimal, especially considering the compensable consequence mechanism of injury to the right knee, that she would have had 50% of those limitations that he described, such as preclusion from running, preclusion from jumping. In other words, the permanent disability descriptors that he provided, he opined that she would have had at least half of those descriptors even in the absence of her employment at Marshall's. In other words, with the degenerative changes that she had on the MRI and on the x-rays, he opined that within reasonable medical probability, she would have already been precluded from running. She would have already been precluded from jumping, and she would have probably had at least half of those preclusions even prior to the date of the specific injury. He stated that the primary treating physician, Dr. Woods, did not take this into account when he discussed the issue of apportionment. And he goes on and he talks about some other criticisms that he had of the of the primary treating physician's medical reporting that aren't really relevant to this discussion. So this went back and forth, and after the defense qualified medical evaluator provided his report, the primary treating physician re-evaluated Ms. Escobedo, and again he stated his apportionment determination by opining that the patient, prior to her industrial injury of October 28, 2002, it should say, 2002, was not suffering from any disability relative to her knees. So here he's letting us know that she had no disability, and according to the apportionment laws in effect at the time, only disability could be apportioned. So he's telling us that all of the disability that she now suffers is a result of the industrial injury, because prior to the industrial injury, she had no disability. And he explains this by telling us that she was able to walk in unlimited fashion and had been able to work. She clearly has disability at this time, which I have, in the absence of previously documented disability attributed to her industrial injury. So for the laws in effect at the time, Dr. Woods provided a proper apportionment determination, but as we said, Ms. Escobedo got caught in the transition, and because her case, the resolution of her case crossed the transition date of 4/4/04, she became subject to the new apportionment laws in effect on 4/14/04. So the workers' compensation judge determined that overall, applicants' bilateral knee disability rated 53%, which is huge. As I said, a medial meniscectomy rates anywhere from 1 to 3% under the AMA guides, and that was the express purpose of Senate Bill 899, was to reduce workers' compensation costs, and this is an example of pre-Senate Bill 899 permanent disability ratings. They're quite high, and these were based on the factors of disability related to work restrictions outlined in Dr. Ovadia's report. The workers' compensation judge also apportioned 50% of applicants' permanent disability to non-industrial causation under Section 4663, relying on Dr. Ovadia's opinion that 1/2 of the disability was caused by her pre-existing degenerative arthritis. And the reason the judge relied on that opinion was because he was convinced that Dr. Ovadia's opinion qualified as substantial medical evidence. Okay, so let's get into the conclusions of the Escobedo case as relates to substantial medical evidence. So conclusion number 1, even where a medical report addresses the issue of causation of the permanent disability and makes an apportionment determination by finding the approximate relative percentages of industrial and non-industrial causation under Section 4663, the report may not be relied upon unless it also constitutes substantial evidence. So, in the absence of substantial evidence, the parties cannot rely on the report. The opinions and conclusions, especially on apportionment, have to rise to such a level that it qualifies as a substantial opinion. And there's several filters that the report must pass through in order, for the opinion to pass through, for the opinion to qualify as substantial. And we'll talk about those. Okay, so just a quick comment. So every report that addresses permanent disability or permanent impairment must also address the issue of the cause of the permanent impairment or the permanent disability. That's the law. So addressing the apportionment does not qualify apportionment as a complexity factor because it's required. Apportionment as a complexity factor is different, and many doctors employ apportionment as a complexity factor when they address apportionment. However, the law requires that we address apportionment, and the complexity factors require that apportionment meet very specific criteria to qualify as a complexity factor. So addressing apportionment and employing apportionment as a complexity factor are different things. So with regard to substantial medical evidence, the court tells us that in this regard, it has been long established that in order to constitute substantial evidence, a medical opinion must be predicated on reasonable medical probability. And you'll recall that Dr. Ovadia used those very terms in providing his apportionment opinion. So always, always, always precede your opinion by the phrase reasonable medical probability, and format your opinion in terms of reasonable medical probability. So in your report, that might say, for example, in my opinion, comma, within reasonable medical probability, comma, 50% of the permanent impairment is due to the industrial injury and 50% is due to other factors. and that opinion is predicated on reasonable medical probability. Okay, so always predicate your opinion on reasonable medical probability. Also, a medical opinion is not substantial evidence if it is based on facts no longer germane. In other words, it must be based on facts that are still germane. If it's based on an inadequate medical history or examination, if it's based on incorrect legal theories, or if it's based on surmise, conjecture, speculation, or guess. And the best way to prove a medical opinion is not substantial medical evidence is to show that it's based on an inadequate examination. What is an inadequate examination? Well, what is an adequate examination? An adequate examination is an examination based upon the physical examination procedures that are described in the AMA guides. If the parties can demonstrate that your physical examination is inadequate, in other words, does not comply with the procedures described in the AMA guides, then your opinion can be proven to be not qualifying as substantial medical evidence. So it must be based on reasonable medical probability, it must be based on relevant germane facts, it must be based on a good history, on a good examination, and it must not be based on conjecture, speculation, surmise, or guess. Okay? They tell us that further, a medical report is not substantial evidence unless it sets forth the reasoning behind the physician's opinion, not merely his or her conclusions. So, building upon our script, your apportionment determination would say something similar to the following. In my opinion, comma, within reasonable medical probability, comma, and then state your apportionment conclusion, 50-50, whatever, 60-40, whatever, period. And then you would continue by saying, reasons for this conclusion include, colon, and then list your reasoning whereby you arrived at your apportionment approximate percentages. List the reasoning. They tell us that a mere legal conclusion does not furnish a basis for a finding. So some doctors simply provide their conclusion. They say, in my opinion, 50% of the permanent impairment is due to the industrial injury and 50% is due to other factors. And that's the conclusion. That's called a conclusory opinion. That is not a substantial opinion because it does not include the reasons. It's simply a conclusory opinion. An opinion that fails to disclose its underlying basis and gives a bare legal conclusion does not constitute substantial evidence. The chief value of an expert's testimony rests upon the material from which his or her opinion is fashioned and the reasoning by which he or she progresses from the material to the conclusion. It does not lie in the mere expression of the conclusion, which is the conclusory opinion. Thus, the opinion of an expert is no better than the reasons upon which it is based. So when you provide your reasons should be both compelling and they should be voluminous, and they should be based on relevant facts. It should be based on your findings of your history. It should be based on the findings of your physical exam. And it should not involve guess, conjecture, surmise, or speculation. So you want to run your opinions through these filters. Ask yourself, when you look at your opinion, is there any conjecture here? Is there any surmise here? Is there any speculation here? When you review your conclusion, you should ask yourself, is this based on relevant facts? And your relevant facts should be cited among your reasons. Okay, so you're going to pass your opinions and conclusions, especially on apportionment, through these filters of substantial medical evidence. Moreover, in the context of apportionment determinations now, this is specific to apportionment determinations, the medical opinion must disclose familiarity with the concepts of apportionment. It should describe in detail the exact nature of the disability that's being apportioned, and it should set forth the basis for the opinion. So you might say in your report, my basis for the above opinions include, and then provide the parties with the bases upon which you formulated your opinion. In this way, the board can determine whether the physician is properly apportioning under correct legal principles. Thus, to be substantial evidence on the issue of the approximate percentages of permanent disability due to the result of the injury and the approximate percentage of permanent disability due to other factors, a medical opinion must be framed in terms of reasonable medical probability, it must not be speculative, and it must be based on pertinent facts and on an adequate examination of history, and it must set forth reasoning in support of its conclusions. And doctors, as we talked about earlier, the pertinent facts that are most important has to do with pertinent facts related to the mechanism of injury. And we'll get into that, and I'll show you how that relates to this case in just a moment. So, for example, they tell us if a physician opines that approximately 50% of an employee's back disability is directly caused by the industrial injury, the physician must explain how and why the disability is causally related to the industrial injury. For example, the industrial injury resulted in surgery, which caused vulnerability that necessitates certain restrictions, and how and why the injury is responsible for approximately 50% of the disability. And if a physician opines that 50% of an employee's back disability is caused by degenerative disc disease, as in this case, the physician must explain the nature of the degenerative disc disease and must explain how and why it is causing permanent disability at the time of the evaluation, and how and why it is responsible for approximately 50% of the disability. So doctors, the apportionment section of your report should be detailed, and it should be full of compelling and voluminous explanations that support your apportionment determination. And the support for your apportionment determination must be based on relevant and pertinent facts. So here's what they found so compelling about Dr. Ovadia's opinion for 50% apportionment to other factors. Here, in opining under Section 4663 that 50% of applicants' permanent disability was caused by other factors consisting of pre-existing degenerative arthritis in both knees, the workers' compensation judge relied on an apportionment determination of Dr. Ovadia. Dr. Ovadia opined that there is a medically reasonable basis, so he predicated his opinion on reasonable medical probability. He said medically reasonable. Medically reasonable basis for apportionment because of the trivial nature of applicants' left knee injury, because of the almost immediate onset of right knee symptoms after that injury, and number 3, because of the obvious significant degenerative arthritis in both knees, which was found on diagnostic studies. So he opined that because she had so much pre-existing degenerative change in her knees, that degenerative change in her knees caused her a great deal of disability of both knees. Well, because the mechanism of injury was so trivial, not all of the disability could be attributed to the industrial injury, which was trivial. Not all of the industrial injury could be attributed to the industrial injury because she immediately developed right knee symptoms as a compensable consequence as a result of limping around on the left knee for only 1 or 2 days. Also a trivial mechanism of injury. Well, in the context of a trivial mechanism of injury, how can it be explained that the examinee has such a high level of permanent disability? And he opined that the high level of permanent disability was in large part due to other factors the fact that she had pre-existing degenerative arthritis in both knees. He also stated it is medically probable, there's your reasonable medical probability, that she would have had 50% of her current level of knee disability at the time of today's evaluation, even in the absence of her employment at Marshall's. In other words, she would have had half of her disability of a complete preclusion from running and half of her disability of a complete preclusion from jumping, even in the absence of her employment and in the absence of her injury at Marshall's. The workers' compensation judge was justified in concluding that Dr. Ovadia's opinion meets the standards of Section 4663 and that it is substantial evidence. That is, it appears that Dr. Ovadia based his opinion on an adequate medical history, on an adequate examination, and on pertinent facts. The pertinent facts were related to the mechanism of injury, as we stated before, and also pertinent facts related to diagnostic study findings. And the applicant did not contend otherwise. They didn't contend that Dr. Ovadia did an inadequate exam, that it was based on facts no longer germane, or that he did not have an adequate history. The applicant did not contest that. Also, Dr. Ovadia's opinion is not speculative, and it sets forth the reasoning behind his conclusion. Further, he states his apportionment opinion in terms of reasonable medical probability. So doctors, this is the key phrase if you want your apportionment determination to be upheld. Always predicate your opinion on reasonable medical probability. Moreover, he does what he's supposed to do because he assesses the relative percentage of industrial and non-industrial causation based on the time of his evaluation of the applicant. Finally, he finds the approximate percentage of permanent disability caused by other factors, which was that 50% of applicants' permanent disability was caused by non-industrial factors, and 50% was directly caused by the industrial injury. So doctors, isn't that fascinating? The Escobedo case gives us an exact recipe, an exact formula to follow in providing our opinions and conclusions. Now, what's interesting is that the Escobedo case does not allow us to substantiate opinions that are off the top of our head, that are off the cuff, that have no basis. Rather, the Escobedo decision and the filters of substantial medical evidence help us to arrive at opinions and conclusions that have a high likelihood of being correct, that have a high likelihood of being accurate, that have a high likelihood of being a true and accurate description of actual events. If we could have perfect omniscience and if we could have a crystal ball, this formula, this recipe allows us to arrive at the same conclusion in nearly every single case because of the tough criteria that the opinion and conclusion must pass through before it can fall out of the bottom of the filters and qualify as substantial. If the opinion gets stuck in any of the filters, it's only because the opinion is probably not true. The opinion cannot be substantiated by relevant facts. The opinion cannot be based upon an adequate examination. The opinion gets stuck in the filters because there's a problem with the opinion. Only opinions that fall out of the bottom, that successfully pass through the filters of substantial medical evidence, are true opinions. How are they true? They're as true as they can possibly be because they're supported, they're based on facts. They're probably the true opinions. So every time you offer an opinion or conclusion in your report related to causation, related to permanent impairment, and especially related to apportionment, you should run those opinions and conclusions through the filters of substantial medical evidence. And here I've provided some text for you that you can import into the body of your QME report to show the parties that you have considered the substantiability of your opinions and conclusions. And this is a statement of substantial medical evidence right here. So tell the parties, and this you would paste into your report after your apportionment section of your report, you tell the parties that the above opinions on permanent impairment and apportionment of the permanent impairment are based upon, number one, reasonable medical probability and my professional experience. So there you predicate your opinion on reasonable medical probability. Number two, that they're based on an adequate history as provided in the medical records and as clarified by Mrs. Jones. So what qualifies your history as adequate? Well, an adequate history contains copious relevant facts related to the mechanism of injury. Can you see how this comes full circle? And can you see how now to construct the history section of your report? And can you see now how to structure your interrogation with the examinee? Your interrogation of the examinee should include multiple questions regarding the mechanism of injury so that when it comes time to provide your apportionment determination has adequate and copious relevant facts from the history section of your report. Number three, these opinions are based upon my physical examination of Mrs. Jones as the qualified medical evaluator, and make sure that your physical examination procedures exactly comply and comport with procedures that are described in the AMA guides. If you don't exactly follow the AMA guides, if I was the defense or if I was a party trying to object to your determination, I would try to indicate that your examination was not adequate. Based on the number of QME's reports and examinations that I've reviewed, many qualified medical evaluators provide for physical examination findings that are not compliant with the procedures that are described in the AMA guides. So you must follow the AMA guides exactly in fashioning your physical examination of the examinee if you want to contend that your opinions and conclusions are based on an adequate exam. So my suggestion is that you brush up on your exam so that it exactly comports with the AMA guides. Finally, if you've reviewed any diagnostic studies, if you've taken any new x-rays or studies for the purpose of the evaluation, make sure you fashion your opinions and conclusion based upon those findings, much as Dr. Ovadia based his opinions and conclusions on diagnostic study findings. If there's any medical research that you can cite that supports your opinions and conclusions, make note of that here. And then finally, remind the parties that your opinions and conclusions are based upon reasonable medical probability and do not rely on any speculation or conjecture. And I'm suggesting that you take this list and look at your apportionment determination or your permanent impairment opinion and look and make sure that it's not based on any speculation, that it's not based on any guess or conjecture, and that it's based on reasonable facts, and that you can support your opinions and conclusions. And when you can support your opinions and conclusions with relevant facts, adequate history, adequate examination, without guessing, without speculating, only then can your opinions and conclusions qualify as substantial medical evidence. And particularly with regards to the apportionment determination, the relevant facts upon which your apportionment determination is largely based, if not exclusively based in some cases, has to do with the mechanism of injury. Okay? So doctors, I hope this helps you. The Escobedo case gives us an exact formula to follow in those sections of our report wherein we have to stick our neck out and provide an opinion or conclusion and provide an opinion in areas where it's impossible to be absolutely 100% certain. But fortunately for the filters of substantial medical evidence that Escobedo provides us, we can be confident that when we arrive at opinion or conclusion that falls out of the bottom of the filters, there's a pretty strong likelihood that that is the correct and accurate opinion for the particular case. Okay, so doctors, I hope this helps you. And in our next session, we're going to go into the fascinating series of cases known as the Alvarez-Guzman line of cases, and how those cases combined with the Escobedo case have radically changed the qualified medical evaluation as we now know it. Okay? So this is Dr. Perry Carpenter. I hope you learned a lot from today's discussion. Look forward to being with you on our very next discussion as well. And for now, I'm wishing you best success in your career as a qualified medical